All right, we're going to go ahead and get started. There'll probably be a few more folks registering here, but we're, 1 minute into our time already. Welcome everyone to Sanderson Firm's March webinar. I have the pleasure of working with Bridget Smith here. She's one of our other attorneys. So we'll be kind of taking care of you today and going through our MSAs, unpacked what every claims and litigation professional should know. If you haven't been with us before, welcome. If this you're an old hat, you've done this several times, welcome back. We are super excited to be presenting and chatting with you today. Before we go off on our route, a couple of just housekeeping items. If you're not familiar with our firm, we were founded by Heather Sanderson. She is phenomenal, and we get the pleasure of working here every single day to do all things Medicare secondary payer, uh, coordinated, or whatever word I want to use there, but that's what we do. We're a law firm. We're nationwide. We solely focus on Medicare secondary payer compliance. I'm one of the attorneys. I'm the senior vice president of legal affairs and compliance here. I've been over here just about over a year now, and I used to do insurance defense work as an attorney in Minnesota. That's where I'm licensed. So happy to be here. I will let Bridget introduce herself, and she's also a former defense attorney. Take it away, Bridget.
Thanks, Annie. And yes, Annie and I have a similar background. As she said at one conference we were at, she's a recovering defense attorney. So I am as well, practiced in workers' comp and liability. And I have been at Sanderson Firm for about 3 months. So I'm very new, but I'm very excited to be here. I am the senior vice president of legal strategy, and I'm so excited about our topic today because we have a great theme. I wish I hiked. I should hike, but I'm looking forward to this hike and taking this trail with Annie. So
Awesome.
welcome.
Thanks, Bridget. So yes, we will be talking about MSAs unpacked, what you need to think about. So how do we prepare? Who's involved? What trails do you take? What happens when you reach the summit? Okay, so for today's route, we are going to be looking at preparation and team, the skills and roles. What should we be thinking about kind of as a claim walks in the door sort of situation? And then once you know you need a Medicare set aside, what are the different types of Medicare set asides? Which is the right trail for the group? This will be a group hike. If you like solo hiking, too bad, so sad. Unfortunately, you're stuck with the group today. And then what happens when you reach the summit? What kind of checklist do you want to keep in mind? So for the prep and the teamwork, we really kind of, we're talking with the idea of claims professionals being on the presentation today and in attendance. We're talking about, probably defense lawyers, some decision makers, right? There's a whole team of people which we're going to get to in a second, but the idea kind of, you'll see if you were a Boy Scout, you'll kind of recognize what I did here. And I said always be prepared. So the trek you're going on does require some amount of conditioning. We're not going on this group hike, without doing some of that. And so Bridget and I wanted to make sure, just to kind of talk through, especially as recovering defense attorneys, the things that we used to think about when we were working with adjusters and claims handlers sending files our way for litigation. So the piece that we're talking about here is just staying in good condition for these MSA hikes, because it's not every single file that you're going to have to take an MSA hike, right? That's certain files. So the kind of always be prepared Boy Scout model is really, if you're handling these claims or you supervise people who are handling these claims, really it's key to follow those state rules and regulations, the treatment parameters that are in your jurisdiction, OGG guidelines, other best guidelines for claims handling that you have, and paying attention to any jurisdictional issues. Do you have a statute of limitations available to you? Are there treatment caps? Knowing kind of in general what Medicare covers and doesn't cover, that is going to help keep you conditioned for these hikes. Bridget, can you talk a little bit about, why it's important to keep the medical and pharmacy records up to date too?
Sure. Absolutely. And really it comes into play because you for a couple reasons. One of the reasons is that you want to make sure that when you go to get an MSA completed, that you have that up-to-date information because it's going to give you the most accurate allocation. You don't want old records that don't reflect what the current treatment is. And also, depending on what path you take as well, if you don't have those up-to-date medical records, it's going to be an impasse for you. You're not going to be able to travel well because, especially with CMS, they want the last 2 years of treatment related medical records. And if the claimant didn't treat, that's one thing that we'll talk about. But if the claimant did treat and you just don't have those records, it's going to be a very big obstacle for you. So you definitely want to keep those up to date and current, and it provides you with the most transparent and clear picture of the claimant's treatment.
Absolutely, because that's what we're trying to do here, right? Like we're talking about conditioning. We're not making you go run a mile tomorrow. We're not making you go lift weights, right? But we are reinforcing this idea of just, doing what you can on the file to keep you in a spot that you're basically ready if the time comes for whichever trail you're going to face. And so part of that is, right, if you have those updated records and those pharmacy records, you're going to be seeing what treatment's coming through, which can then also help you mitigate the claim as you go. If you're able to direct care in your jurisdiction, right, making sure that they're not treating with an unauthorized treater, making sure that you're questioning the providers on treatment. Is a surgery recommended? What does that mean? Is this something that the person wants to undergo? You can question the reasonableness, the necessity, right, for medications. Is there a causal relationship? Were they taking this medication before they got hurt? What about the time frame for a prescription and pushing for generics? All of those things are going to set you up into a really good spot no matter what trail you're facing. And then when that person is medically stable, that claimant, that is when you want to question the need for future treatment. Of course, it's really rare in work comp to get a treater to say no future care, but heck, it's worth a shot. And then making sure that the doctor clearly states what is and isn't recommended in future care. One of the things we see sometimes with unclear medical records, if it's not clear if it's related to the injury and you have to take the trail that says you're going to CMS, then that's coming in. Even if it might not be related, if it's not clear in the records that it's not related, that's what you're looking at, when you take the arduous, CMS trail. So the other thing you want to be thinking about too are consequential conditions, personal conditions, right? So you've admitted the right knee, but now they have a consequential psych and you're denying that maybe. That needs to be documented. You don't want to accidentally pay for their Prozac on that then, or that could be coming in depending on what trail you end up taking. And then documenting those personal or pre-existing conditions is key. So the medical records and pharmacy records will leave you in a really good spot to mitigate care timely and keep you on top of that so you're ready for the MSA later. And then just also containing costs and things like that. Bridget,
Yeah.
one of the other things that we say on this slide is we talk about, ensuring that the claim notes, the medical providers are using clear and appropriate diagnosis codes and especially ICD-10 codes. Can you talk a little bit about that? And of course, add anything else I might have missed too.
Sure, sure. So ICD-10 codes are going to give you the most accurate coding and specific coding. ICD-9 codes are very broad, and so it opens you up to more liability. But the ICD-10 codes are really important because they're more specific. They give you an accurate description of the specific part of the body that you're treating, and also really the macro level of that. And I wanted to go back to something you said, Annie, too, about really prepping for the case. And I always say this, an MSA doesn't start when it goes to the vendor. It starts at the claim desk. It starts when you're deciding what to pay for. It starts when you are reporting to CMS if you're responsible for medical and you're reporting certain diagnosis codes that may or may not be related. It really starts when you're looking at those treatment records, when you're deciding maybe whether to file a utilization review because some of that treatment's not going to be reasonable or necessary. And you guys are the first line of defense because once it comes to us, we're looking at what is done on the claim. And if you pay for something, especially on that Medicare trail, Medicare is going to look at it as you bought it essentially, and it's really hard to backtrack that. The other thing I would say too with this is when you're questioning providers and trying to figure out future needs, try and be very specific about those questions. Don't ask it too early on in the process, because what you don't want to do is ask an open-ended question and then all of a sudden the provider is telling you the claimant needs everything under the sun, because remember, they're advocating for that claimant. They want to make sure everything's in there, and sometimes they don't realize that something that they mentioned that could be a possibility, CMS will take as a probability when they do the MSA. So, you know, figuring out the timing on this is also really, really important. But it really starts with you guys. And that's why we call it conditioning, because you're setting up the case, you're setting up the trail, you're setting up really what that MSA is going to look at. So diligence on that part, it can be overwhelming. And I know, this is only part of the claims adjuster's job. They have so many hats that they wear, but it's so very important when it comes to the MSA.
Absolutely. Well, thank you, Bridget, for adding that. Okay, so remember, we said it's a group hike. And we talk about conditioning first because it does really start at the desk level, with the claim walking in the door, right? So the one thing that we want to encourage you to do is be curious. Like, that is a huge thing for me here at Sanderson Firm, and just how I lead my life is I try to come from a place of curiosity. Oh, this thing happened. Why did that happen? Right? What can I do about it? Is this a training opportunity? What can I learn from this? Right? So there has been, and I've heard people refer to it as the path of least resistance, which is CMS submission, but I actually think that's the path of most resistance.
Yes,
It is the
agree.
most arduous trail.
Yes.
And not because it's like, this isn't El Capitan, right? Like, we're not in Yosemite scaling the largest peak or something like that. It's really arduous because it's a trail that is not maintained. And they've thrown obstacles in the way, like obstacles have fallen in the way, or they put them in the way, and it becomes arduous, not for, the reasons that we would think about a trail being arduous, for really kind of bureaucratic reasons. So we're telling you, be curious, kind of have an idea of the paths and the trails, so that you can get the experience that you seek. And that means everyone on your team, right? So carrier self-insured, right? They have, Medicare secondary payer provisions. The third party administrator, if they're involved, might have Medicare secondary payer provisions and MSA, preferences. Is there excess or reinsurance involved, right? That person should be on the team too. The defense attorney is often the sort of the hike leader in a lot of ways. I felt
Mhm.
that way, because the file would come in to the door to me. I did my initial report, right? I go over the exposure, I tell you what we're thinking, and hey, this person is 65 years old or older. You've already told me they're on Medicare. We got to be thinking about a Medicare set aside. It is imperative that you all kind of are aware of the trails, because if that defense attorney doesn't know the trails, then the next person in line has to tell them. That's the adjuster, right? Or that's, the third party administrator getting involved. And then they need to know which Medicare vendor then to send something to. So the key is really partnering early and often with any of these folks who are involved, so that it is a successful group hike and we're not leaving anyone behind, or somebody doesn't get it wrong and send it to the wrong vendor. I've seen that happen before. So
Mhm.
really, it is a group hike. This is going to get you your best in class MSP outcome. Anything to add, Bridget, on the team here?
No, I think that's great, Annie, because that's absolutely the right approach, right? Just a team approach. And also, if you already know the path you're going to take and your team doesn't, that's something you need to maybe correct beforehand. Because if you have a program that's already in play, you know what kind of path they're going to take, you know what type of MSA you're going to utilize. Make sure your defense counsel is aware of that, so they're advocating for you with plaintiff's counsel or claimant's counsel, so they're aware as well, so everybody's expectations are set, no one is off the grid, and you're all working together, because the smoother the trail is depends on how smooth your team is able to track it. I'm using all these terms, and again, I don't hike, but
You're doing great.
thank
I would think you were a pro hiker.
you. Thank you.
Okay, so we're going to come back to our slogan of always being prepared. So we talked about the team, we talked about the conditioning. Now it's really, what are you looking out for? And everybody on the team is looking out for this, but in particular, the adjuster and the defense counsel involved. That's who's really kind of looking at these and digging in every step of the way. There's obviously the investigation that happens when the claim gets reported. And then if you're in a jurisdiction like I was in, I could take a deposition. So in Minnesota, I would sit across from folks and I would ask a lot of these questions. I would have already hopefully had some of them answered, either from the discovery that had happened before or written discovery. But these are the things that should start the MSA trigger. This starts you thinking about, hey, I got to start looking for an MSA trail. You know, you don't have to decide which one just yet, but it's going to tell you you're going to be going on an MSA hike, right? So what are these triggers? Is the claimant on Medicare already? Then we know. Are they 65 years old or older and not yet on Medicare? We got to do something. We can't do nothing. Age 62 and a half years old or older and not on Medicare. We got to do something. That's a reasonable expectation. We're looking at whether the person receives Social Security disability insurance benefits, right? Because if somebody's received those benefits for 2 years or more, they're eligible for Medicare. We are thinking about folks who plan to apply for SSDI, or they're going to reapply. They've been denied and they want to go again and reapply. That's somebody you want to keep an eye on because they have a reasonable expectation of becoming a beneficiary. One thing that I looked at when I was in private practice, so I did include it on this slide, is hey, is that person's spouse or someone in their family on SSDI? Um, it doesn't necessarily mean secondary gain, right? I have that in parentheses. I don't want to be like, you know, the cynical defense person that I, you know, might be at times. Let's give it the benefit of the doubt, right? At a minimum, if somebody in that household is on SSDI, that tells me that they have either they've gone through the process and either they know how to be successful at it on their own or they have an attorney, they're working with somebody to help them get SSDI successfully. So that increases the likelihood that this person then could potentially apply. Obviously, if it's a catastrophic injury or something like that, you probably have a good sense. Bridget, do you want to cover the three bullets on the right then? I mean, I kind of talked about catastrophic, but you want to cover those three?
Sure, sure. So, does the claimant plan to apply for SSDI within the next 30 months? It's that reasonable expectation approach that we want to look at. And I think it really this slide is very good because often we forget this slide, right? It's the basics. It's really the basics. It's your water bottle, right? It's basically it changes the complexion of the case when these things are part of it, right? If you have a catastrophic claim, like Annie said, this individual probably at some point is going to be on SSDI or apply for it. So automatically in your head, you're thinking there may be some Medicare implications here. And that's what we're really looking at. And then the last one is kidney issues, end stage renal disease. I think you probably know that there might be some indication in the record, but it's another inquiry. So really what we're saying here is that age is not the only determining factor. I still hear today sometimes when talking to folks that they'll say, well, they're not 65, and automatically my I just out of my mouth comes, well, it's also disability. There's also disability here that we're talking about, which is the other fact that creates Medicare eligibility or an expectation of eligibility. So the other thing that is important too is we're in a different age now. We have what Section 111 has given us, the query process. So we can easily check Medicare eligibility through that query process through Section 111. And you can do that. It used to be, like Annie said, back in the day, we do depositions. We would be in court asking. We could do interrogatory saying, are you Medicare eligible? Have you applied for Medicare or for SSDI? Those types of things. And now we have that query. So utilize the query as well to see if there is a Medicare beneficiary that you're dealing with. But definitely these are the triggers you must be aware of because they're going to create that Medicare indication to let you know that you need to protect Medicare's interest in this case, and you need some type of allocation to do so. And we're going to talk about that as well.
Yeah. And one thing to keep in mind here is, these should kind of trigger some sort of action. The end stage renal disease may have nothing to do with your claim, right? The
Mhm.
reason why they're on SSDI may have nothing to do with your claim, right? They have a
Yeah.
pre-existing injury. So just the fact that they're on means you have to do something with it, even though it's not your claim. So we know that that's tough. That's hard. We did see a question come in through the chat about, what about if you just have a 30-year-old? Well, the 30-year-old you want to take a look at. Is any of
Yes.
this information triggered, right? If it's not, then if you don't need an MSA and you get to kind of proceed like you would with any other claim, the key is putting language in that just shows that the parties have considered Medicare's interest, and you can do that, right? So if I were settling out a claim today, it would say, Annie Davidson is X number of years old. She's not a Medicare beneficiary. I don't have a reasonable expectation of becoming a Medicare beneficiary in the next 30 months. Under the current guidelines, the parties have considered Medicare's interest and Medicare doesn't have an interest in this case, something along those lines.
Yeah.
So yes, if you could kind of get through the analysis and they're young enough and you don't have to think about it, then you just kind of proceed like you would with any other claim with just some of that language in there. Okay,
And
we're
and
gonna.
that's a good
Oh,
point,
go
Annie,
ahead.
because it's a really good point to say that too, because even if in your settlement documents, that's one of the best place to solidify how you're protecting Medicare's interest, and if you don't have to. So, I love that point because that's something often we overlook. Just put it in there. Just put the blurb in there that you've looked at that and it doesn't apply here. Okay, but we're on the Medicare trails now.
All
We're
right,
we're
we're on our
Medicare.
trails.
Yes.
Okay. So which MSA trail is going to be best for the group? So basics, right? This is your equivalent of like leave no trace behind, right? As a general rule, no matter what trail you go on, you are going on a trail because future medicals are being released. The individual claimant requires claim-related Medicare-covered medical care. We'll talk about zeros down the line if you're, we're not going to go this route of allocating. And then the claimant is a beneficiary or has a reasonable expectation. That is what it is, what it is. We've been dispelling this notion that, if you settle a case for $25,000 or less with a beneficiary, you don't have to do anything. That was never the case. Did we do it? Yes. Did people in the industry do it? Yes. That day is gone. So we have a
Mhm.
note at the bottom. Medicare's workload review thresholds for submission are irrelevant for determining when you need to go on one of these trails. You have to go on a trail if medicals are being released, the claimant is on Medicare or is going to get on Medicare within 30 months, and they need future care. So that's something just to keep in mind. In terms of choosing the right path, we're going to start talking about um, the traditional work comp MSA and submitting evidence-based MSAs. That's really if you need Medicare approval. The statute itself, right? 42 USC 1395 YB, you look at the plain language of that and how it's interpreted. You have to reasonably recognize Medicare's interest. So the ways you can do it vary. That's why we have all these different trails. So, I think everybody pretty much knows my philosophy, and I think Bridget has pretty close to the same philosophy as me. Why am I going to participate in this voluntary program that, I'm not forced to go into unless the other side is making me do it. Obviously, we know I've got clients who are more conservative and we get it. So if you want to follow the process, we got you. We're going to talk about that first. Then we're going to spend some time talking about the IMSA, which provides some more speed, flexibility. It's still compliant with recognizing Medicare's interest, but there's indemnification offered because you're not submitting. Then we're going to talk about those zero MSAs and kind of the world we live in now because, newsflash, Medicare stopped looking at them last year. And then AMSAs, our abbreviated MSA. We want to talk a little bit about that product because what happens when you're settling a claim for $25,000 or less and Medicare won't look at it, right? They have those workload review thresholds. What do you do with that low dollar exposure? And then we'll talk a little bit about some other products that the Medicare medical cost projection or a pre-MSA, when those might slot in. So, Bridget, do you want to talk a little bit about the, longest, most fraught trail out there, CMS submission with a WCMSA?
Yes, Annie, it is not for the faint of heart. I will say this. So, this trail, you have to follow Medicare guidelines. Medicare has said if you submit to us, you have to do what we say. And they pretty much stick to that. So, we know they're only going to look, as Annie said, at certain cases. They're not going to look at every single claim you have, regardless of the settlement amount. They only want you as part of their workload review threshold. And again, this is a workload review threshold. They want to look at only those cases involving Medicare beneficiaries where your settlement amount is greater than $25,000. So that's the first part of it. You can also submit to them on this trail. You can also go on this trail if the claimant has that reasonable expectation that we talked about within 30 months of that settlement date. They have a reasonable expectation of Medicare eligibility. So like we said, they're 62 and a half. They apply for SSD, or they were denied and they're going to appeal, or they're going to reapply. And the other caveat of that is that the settlement is greater than $250,000. So in that respect, they're looking for somebody close to Medicare eligibility where you have a high enough settlement that it makes sense for them to look at. So you can only go on the MSA CMS submission path if you meet that workload criteria. Then when you go on that path, you have to understand that there are some things you need to be aware of. There could be potential pitfalls. And one of those pitfalls, and I think one of the biggest pitfalls in going on this path, is that we talked a little bit about the medical, right? You really do, when CMS says we need the last 2 years of medical, they hold you to that, and you have to prove a negative. So let's say that you have a claimant who stopped treating. Basically, maybe they started treating for another condition. I've had cases where claimants have life-threatening conditions they treat for instead of the work injury, right? And they just stop treating with those providers for the work injury, and there's not something in the record that says claimant's not treating anymore today, we'll never see him again, right? It's not clear. CMS will want you to prove that that claimant hasn't been seen by that provider since this date. And so you have to go back to the provider, you have to get those medical records, or sometimes the provider's not in business anymore. So then you have a bigger issue. So you're really having to go and prove the negative. Even though you have payment screens showing that you haven't paid anything more on the claim, showing that medical treatment hasn't occurred, you're having to go back to the providers. So this can take a while. This is one of those pitfalls to the path that you need to be aware of. The other thing on this path is if it's mentioned out of a provider's mouth, CMS will most likely include it in that MSA. So if surgery is recommended and maybe the claimant is not able to undergo surgery because they don't qualify for it, they're not cleared for surgery, that's going to be something that CMS is still going to consider. If someone just mentions he could have surgery, he could have a spinal cord stimulator, he could have this, CMS is going to include these things. So whereas, when you have somebody who's looking at this from an evidence-based approach, not all of those modalities are going to be included. CMS is going to include that. So that's why we say this path is a little more treacherous. There's a lot of booby traps on this path that you have to be aware of. The other part is if you have state statutes that you can abide by as an adjuster, right? You don't have to pay because of these state statutes or because of this determination or because of this report. CMS will probably still include it unless you have a court order. And realistically, sometimes you're not going to be able to get that court order depending on the jurisdiction that you're in. And depending on the parties, right? Claimants counsel might not want to do that. It might prejudice some other part of their case if they have a third party liability case or what have you. So it really puts you in a bind because, again, we're looking at a more rigid standard. We're not looking at just, what is probable. We're looking at what is possible. And Annie, what are some of the other things you're seeing or some additions to this as well that when you look at this path?
Well, I think we call this like rough passage just because, of these pitfalls that you've highlighted. And really this idea that Medicare is stuck in their way of thinking. So they force us into using an average wholesale price for a drug. There's no such thing. Average wholesale price is just averaging the wholesale prices. It is an amount that Medicare would never pay for a drug, right?
Right,
So there's some like just artificial things involved, and it doesn't take into account what's going on with that claimant always in the real world. This person
right,
could be getting 4 epidural steroid injections a year for their back that they're having a really good outcome with. Guess what? When we allocate with a traditional Medicare set aside, there's only 3 epidural steroid injections going in for that person's life expectancy, no more. 3 total. And then, if they've been recommended for surgery or a spinal cord stimulator and they're on opioids, guess what? You're going to be paying for the psych eval. You're going to be paying for the trial for that spinal cord stimulator. You're going to pay for the implantation. And those opioids are going in for life expectancy because Medicare doesn't know what's going to happen. So Medicare really takes this worst case scenario idea in some ways and forces overfunding. So I think that's the key piece to keep in mind. And Bridget, you already talked about this with the records. If the records are not up to date, you will not be able to continue down this trail. And if
Mhm.
this person hasn't treated and you don't want to send them back and they don't want to go back to the doctor, then you're stuck with the records you have, and it could be perfectly reasonable to allocate based on that, not this idea that you force the person back into the doctor's office just to make Medicare look at your file. So I think those are the other kind of key things that come up for me is there's a lot of just outdated, treatment recommendations, some overfunding, and this idea of, Medicare says you have to protect their interest, and you hear folks talk about it. You'll even hear us say it sometimes. My whole mantra is no, you protect your client, right? Like you're protecting, you're handling the file properly, you're doing all of that stuff. And you have to reasonably recognize Medicare's interest. You're going to consider it in a reasonable fashion. That's really the key to any of this is what is reasonable. And there's lots of different ways to get there. So rough passage here. We want to talk a little bit about a trail improvement, right? Okay, so you are still going to go to Medicare and you're going to submit. If you're doing the traditional route, that's fine. We talk about what has to go in there. It's going to be written to Medicare standards. It's going to be priced according to their standards. We don't get to leverage any, advancements that have happened with evidence-based medicine. We don't get to leverage any of that. We stick with, what Medicare's worst case scenario is. The trail improvements, the kind of, maybe we have a slight workaround and you're still heading up the path, is to give Medicare an MSA that's been written to evidence-based guidelines and standards. That is a path that you may want to consider. And frankly, if you hired me in-house, one of you guys snatched me up and brought me in-house tomorrow to run a Medicare program, right? Heather would be really sad. So would Bridget. I can already tell. But you call me in and you say, Annie, what are we going to do? Let's build a program. I'm going to build for you a non-submit program. It has nothing to do with the fact that I work here or that I've worked at a place prior to this that did, non-submits. It truly is the way to go if you want to appropriately, manage the costs of a claim, I think. But okay, we know a certain amount of these we really want to submit. That's fine. What I want to do is I want to go into Medicare with the lowest clinically defensible amount then. I want to say, here's what the evidence-based guidelines say, ACOM, ODG, what are the state-specific guidelines, and project future medical care that's reasonable in that fashion. Because to me, that is me reasonably recognizing Medicare's interest. Also, by the way, I bolded it on here. The WCRC is the workers' compensation review contractor. That is Medicare's contractor who looks at all of these submissions. In the reference guide, which is Medicare's sort of Bible for MSAs, right? They say in there that the WCRC does rely on evidence-based guidelines as resources in determining future treatment. What's awesome about that is here with our EMSAs, we put their feet to the fire. We say, okay, you've said you'll consider it. We're going to do that. We're going to price it out on evidence based, and we're going to, we'll show you all of our work. This isn't a race to the bottom. This is, hey, this is what's reasonable, and we will submit that to Medicare. So what's great about that is on average, you're probably going to bake in about 68% savings when you compare it to a regular MSA. And Medicare actually does come back and approve some of these as submitted, or most of the time, and this is my talking about my life here at Sanderson and my life prior to Sanderson, I saw Medicare maybe countering higher, but not nearly as high as they would with a traditional MSA. So there is cost savings that you bake into the evidence-based allocation to begin with. And by the way, this just isn't just for defense. And we can have these conversations with the other side too, because no claimant or defense attorney, or excuse me, plaintiff's attorney wants to be locking up more money for future care for that person than needed, because an MSA locks that money up, right? An MSA is a bag of money that we're handing over to somebody to use to pay for their future care. And if you overfund that, that's just more money that sits locked up. And if that person dies, if you don't have a reversionary interest to get it back, it just passes through their estate or to their family, right? So nobody wants to lock up more money than you need to for future care. This is a phenomenal way to do it. Is put an evidence-based MSA, through submission with CMS to put pressure on them to kind of get with the real world. What did I miss, Bridget? Any advantages that I didn't talk about? Any other
No,
thoughts you have on these?
Annie, no, I mean you're right on with that, and I just can't highlight enough the the this tool for you for people on this call, because honestly it reminds me of that Robert Frost poem. Two roads diverged in a yellow wood, and I took the one less traveled. Take the one less traveled. Take the evidence-based MSA approach, because you're still submitting to CMS. And for those of you out there that have programs that are submit programs, great. You just want to make sure that you're set in the right way to make sure that you're avoiding um, extreme costs and exposure, and that you're wasting time and energy on something. Make it clean, make it quick, and use the best tools out there. And I will say this is the best tool out there. You're still submitting to CMS, but you're meeting them where they are. You're using the guidelines that they said they're going to utilize, and you're literally telling them how they fit in the case. So I really believe that it is a tool that is not utilized a lot, that should be, because it's going to basically give you the most bang for your buck. And you can use it on any case you're submitting to CMS. You're going to see those cost savings. As Annie said, we're seeing extreme results from these. We're seeing CMS accept some of these. We're seeing CMS maybe not accept the whole amount in some cases, but utilize a great deal of it. So we are seeing success. We have the history to prove it. And then those settlement dollars aren't all taken for the MSA. They're utilized for the claimant to resolve the case. And so I really believe that this tool is one that you should be utilizing as often as you can if you have a submit program, for sure.
Yes, if you have to get on the submit trail, this is a key thing to consider. Absolutely, there's nothing stopping you from going in with the lowest clinically defensible amount and having Medicare counter. I know people have been historically been afraid of counter hires, and I've participated in RFPs in the past where, a carrier's asking like, what's your, initial submission pass rate for approvals and stuff. And I get that that's a metric, but I don't want, to be writing overinflated allocations that then spend more money on the claim if I don't have to. I really want to bake in those savings and force Medicare to tell me why, what I did isn't maybe reasonable. So we do have these things to consider, and we will be getting copies of the slides out to folks as well. So we talked about submission, right? And Bridget kind of talked about this already, right? We know that there are obstacles in our path. They are not good at maintaining these paths. In fact, they put things in these paths that make it hard for us. They gatekeep what they're going to look at, right? They use a workload review threshold. So there's just a certain amount of cases they frankly just won't look at. What do you do when you're in that space? Is there any way you can still feel protected, right? Because the bargain, if you submit, is that Medicare is going to, the big carrot they're going to give you is they're going to approve that amount, and they will stand by that amount forever. Even if your deal falls apart, they'll stand by that amount forever, right? So the parties could come back to the table in 5 years and you like that amount, you guys can still settle. That's great. But you have to give up your rights to appeal. You have to go with their number. You're not totally stuck with it. Again, it's a voluntary process, right? But that's a pretty big thumb on the scale if you're going to look to settle. So they gatekeep, they force you to give up your rights. They don't always let you accurately account for what's pled and being released. I've had this fight, where they're adding body parts and conditions that literally aren't even claimed, that haven't
Yes.
been paid for, and they're just completely unreasonable. It avoids that overfunding, and you can use drug pricing that a PBM. If that person's going to use GoodRx once they leave the work comp system, we can price it using GoodRx. If they're going to get professional administration, we can work with the professional admin company and get their PBM information. And then the other key thing with this is if you're not submitting, there's indemnification available. There are entities out there, including Sanderson firm, where we will indemnify all of the parties. That's kind of a big thing of ours, is we're going to indemnify the claimant, the claimant's attorney, the defense counsel, their firm. We're going to indemnify the employer, the insurer, the self-employed insurer, the third-party administrator. Everybody involved will get that indemnification with an IMSA. So, Bridget, do you want to talk a little bit about indemnified MSAs? We know this is a path of non-submission, so we're looking at taking this trail. What do we need to know about this trail?
Sure. I think the first thing we need to know about this trail is that it's not closed. It's open. Nothing that has happened in the last few years has changed that. There's a lot of information out there, and people have said incorrectly that, with all the Section 111 reporting requirements and with the reporting of a WCMSA, that somehow that changed the voluntary nature of non of submission, and it did not. That's still voluntary. You still very much can utilize an indemnified Medicare set aside or a non-submit MSA, and you don't. That's there's no law saying you have to submit to CMS. So the law hasn't changed. And so the first thing is to understand that the law really, as Annie said before, requires you to reasonably consider Medicare's interests. And the way you do that is various ways. One is you can submit, but the other way you can do it is with a Medicare set aside that is not submitted. With an indemnified Medicare set aside, it's not submitted to CMS for review because it's not required to. And we utilize that evidence-based standard that we were talking about before with the EMSA. So we're going to look at what is probable and not what is just possible. So we're allowing you to settle the claim without waiting to go through that CMS review process. We're looking at the medical records just like CMS would look at those medical records, right? It is the claimant's treatment records. We're also looking at any state law that is applicable as well. So we're looking at the totality of the circumstances to come up with an evidence-based MSA that is based upon the facts of the case, utilizing the methodology as far as fee schedule like CMS would use. The difference is that we're making it more realistic. We're making it based on an evidence-based approach, and also we're indemnifying you. So that indemnification is in the event, the unlikely event, because none of us on this call or that I know of are aware of CMS coming back and saying that an MSA was insufficient to support future medical. And Sanders and Firm definitely has not had that happen. So what we're saying though, in the unlikely event that that would happen, because CMS would have to cross a lot of hurdles for that to happen, we'll come in and we'll make those arguments to CMS, and if unsuccessful, we'll indemnify. So it's the belts and suspenders that are part of this, right? Because a lot of folks, what they say is, maybe we would try an MSA that's non-submit if we had some assurances. Well, this part of the trail gives you that assurances. You have a guide with you. They're there to you to the end, till death do you part. They're going to reach the summit with you, and they're going to be there after settlement if there are any issues. So it's an opportunity for you to settle your case in an expeditious way, knowing you've protected Medicare's interests, knowing you're doing the right thing for the claimant, but also making sure that you're protected in the event anything should happen in the future. So really that's the main part of an IMSA. And plus you're getting that cost savings because again, it's not overinflated. And I think that's something that you should consider. And if it's not something that you want to do, it's definitely something that's available to you if you want to look at that. And any please add anything more here, but it's really, we can't say enough about it, honestly.
Yeah, no, and this is available in every jurisdiction across the US. It's available in federal, it's available. Again, at the end of the day, participating in Medicare's voluntary process is just that, voluntary. Yes, it's been around for 25 years, but I think the industry did a really, disservice to the MSA industry did a huge disservice to the work comp industry running around 25 years ago telling everybody they needed to do an MSA, they needed to submit that MSA. That's never been the case. MSAs are voluntary, as is submission. There are some questions coming in that we are not going to answer live, but we will follow up with you afterwards, kind of around like, how does the indemnification work? In general, it covers the delta, the difference between what you fund for an MSA at the time of settlement and the total settlement value. Medicare can never force somebody to spend more than what the parties settled for. So one of the questions is what happens if treatment gets cut off because Medicare doesn't accept an MSA? That doesn't happen that way. We'll talk about that. We'll answer your email but it doesn't work that way. Medicare can force that person into a spend down for up to their future care. The indemnification steps in and wrangles with Medicare, but we're not going to get into more of those specifics, but they are great questions. Keep them coming and we'll answer them later. There was a question if you get a counter hire, if there's a rebuttal. Medicare does not allow, there's no appeal process for their determinations. You have one more shot with an amended review that you can do, immediately now as of April of last year. That's kind of your rebuttal. If there's an error, you do have immediate re-review processes available. We're not going to get into those, but we can certainly answer you offline if you have more questions about those with the counter hires. But we are going to keep cruising along here for the sake of time. Trail closure. There is a submission trail closure for zero allocations. You cannot submit these to Medicare as of July of last year. They don't want to look at them. The trail itself remains open in terms of reasonably recognizing Medicare's interest. You can still go, you can still look at the outlook and survey the land, but you'd be looking at doing a zero IMSA. If you want added protection, you can certainly just add language into your settlement. The criteria that we have up here, there's 4 bullet points. This really talks about when Medicare says you can demonstrate their interest is protected. Medicare put these into the reference guide last year, so they're there for you. It's really codifying medical zeros and legal zeros. And what do I mean by that, right? A treating physician has said no future care, or a court has ordered, no future care for that injury. That would be kind of your medical zero. There's no basis for future care. We'll write you an MSA all day long if you want it. You can actually just attach that, evidence to your, release documents, your settlement documents, your CNR, whatever you call it in your jurisdiction, and sort of move on. That shows you've considered Medicare's interest and Medicare doesn't have an interest. And then the other path is the legal zero. It's a denied claim. There's been no benefits paid, or maybe they paid, during a pay without prejudice statutory window. That path is still available. Medicare just won't look at it. So again, you can get an MSA written. You can even get indemnification from us for that. But this is a trail closure in terms of submission. We have the advantages in here of the zero IMSA. It's total cost savings because nothing's being allocated for future care. A legal zero basically just acknowledges the fact that Medicare is the primary payer and will remain the primary payer after the case settles. There is no secondary payer issue because it's not a valid work comp claim. The parties are compromising only. So you'll see this when the slides get emailed out. And then the other thing to keep in mind in terms of, the overall trail to Medicare is whether you submit or not. As of April 4th last year, Medicare said via Section 111, you heard Bridget talking about that earlier, right? The mandatory insurer reporting. Medicare wants to know what's happening on your claims involving Medicare beneficiaries. This is only for work comp claims with beneficiaries. Any payment for more than $750 triggers a requirement that if you're submitting a TPOC, a total payment obligation to the claimant, a settlement to Medicare, for more than $750, they want to know how much of that settlement is for future care. So you're not only is Medicare getting the total settlement amount, but they're also getting the MSA amount, right? So they know how much money the person got in total and how much is dedicated for future care. Doesn't matter if you didn't submit. Doesn't matter if it's under the workload review threshold. This is really getting at if you behaved in a fashion that said, I settled your claim for $24,999.99. Nope, that's gone. It was never a safe harbor and Medicare's on to you. So you got to do something. You can't do nothing. Doesn't matter if it was a fully denied claim or you had ORM yes for one body part, ORM no. Doesn't matter if you have the letter from the treating physician. They will take zeros. You can put a zero in, but something has to be reported. So Bridget, what happens then if somebody has an under threshold MSA, right? We just talked about that. This is our safety gear check. I can't submit to Medicare. There's no way I can submit. But I need a funded allocation. And I'm settling for like $25,000 or less. What can I do?
So in these cases, Annie, and I think it's important to note too that because of this WCMSA requirement for Section 111 reporting, everything is transparent for CMS, non-submits and submits, right? Threshold and non-threshold. So if you have a smaller case, And you maybe before weren't considering an MSA, even though those were workload review thresholds. You can now, consider, okay, I probably need an MSA here. I want to take into account Medicare's interest, but I don't want a full-blown AMSA. I want it more of an abbreviated, I'm not settling for as much. This is why we have the abbreviated Medicare set aside. It allows us to do an allocation, but it's not a full-blown allocation like you would do for something that maybe is above threshold or something that's a little bit more as far as settlement value. It's for those cases that you're settling at a smaller cost. You still want an allocation. You don't have to give all of the medical records. And again, it indemnifies all parties. So it's a way to protect Medicare's interest. It's a way to put something in that box for the WCMSA amount that allows you to do it in a more cost effective way, a cost effective manner. So this is an option that is available as well.
Yep, absolutely. You want to do something, and this is, you're not just two attorneys, the defense attorney and claimant's attorney, guessing in the night, right?
Yeah,
You've got
exactly.
something. Okay, we are rounding out our hour here. We're coming into kind of the last few minutes, and so the other trail tools we wanted to talk about quickly are medical cost projections and pre-MSAs. So a medical cost projection is going to give you the total amount projected for future Medicare covered and non-Medicare covered items and services. It's not intended for submission. It really can help with settlement negotiations, catastrophic claims. Also, it can help with exposure, even, right? Understanding what the exposure
Mhm.
is.
Sure.
So it's definitely a tool in your toolbox that will get at kind of the full exposure of a claim if that's something that you're interested in. And then pre-MSAs are kind of a way for you to kind of dip your toe in the water and sort of say, hey, what are some key cost drivers and recommendations that I can look at if I have to get an MSA down the line? And the pre-MSA, if you order an MSA within a certain amount of time, it's usually credited towards your full MSA. So both really cool tools to have and to know that are out there in the wilderness with you if you need them. Bridget, any last comments on this before we kind of move into our checklist?
No, I think what we've shown you here today basically is that there are options for any case that you have. You just have to pick the right option, right? And you need somebody who can help you decide that. It may not be apparent on its face. You might not look at your case and say, okay, I need this type of allocation. Um, Work with your vendors, work with us. We will lead you in the right direction if you're unsure.
Yeah, and one key thing, I'm going to answer a question live that came in through the Q&A. If you have old records, right? So let's say you can't go down the submission path because you don't have current records, right? The person's not treating the provider. We've had this happen, right? The provider's in jail. They were running a pill mill. They don't exist. You can't send them back there, right?
Right.
And you still want to settle. That's your square peg round hole case where you definitely want to use a vendor for an IMSA or an AMSA. We don't need the most recent record. Like if they haven't treated, we'll kind of take what you got. So send those over, and that's pretty much any vendor who does these. But we'll take a look at what you've got and we'll project out from there. We're much more reasonable than Medicare in that realm because we know, like we've done it, right? I've been there in the trenches. Bridget's
Mhm.
been there in the trenches with you. Like
Yeah.
what happens at the state level, like that's the other thing to keep in mind. All of these paths exist because there's no statute governing MSAs. There's no regulation governing MSAs. They are truly a made up concept that an agency came up with. We deal with agency guidance on this. And so, yes, it is the industry standard to do something and allocate, but you have options. Don't be afraid to use them and really kind of look at what's best for the group. So yes, we can work with you. Like these products exist because Medicare is so rigid and just won't take what the parties have. And they're not very trusting either. If you think about your most, paranoid relative at Thanksgiving, I always say, that's Medicare, right? They're very paranoid that they're not getting what they need. Okay. Let's keep trudging along here. So reaching the summit, we really just kind of have one slide. We've made it. We're at that outlook. The whole group is there. We might be huffing and puffing, right? We might not be as conditioned as we thought we were. We might be chugging water, whatever it is, but we're at the summit. You've got your settlement agreement, your CNR, your stipulation for settlement, whatever your jurisdiction calls it, right? What needs to be in there? If the person is on Medicare, you have to be talking about conditional payments. If Medicare made payments for treatment during the pendency of the claim, Medicare has to get repaid. Who's doing that? How is that getting taken care of? You heard Bridget talk about leveraging the PAID Act data through Section 111 reporting. That query process, we now know if there's Advantage plans and Part D plans. How are they going to be resolved? That has to be addressed as well. By the way, those are the people who will sue you for double damages, right? The traditional Medicare, they'll get it sorted out. They'll get their money through the Treasury Department if they have to, through an offset, not Part C and D plans. Do the parties intend to cooperate? If something goes awry and you have to get with Medicare, our release is going to get signed. Is that going to be in there? Get the waiver of the private cause of action if you can, and then lay out future medicals. What trail did you take? That's what you want to tell Medicare. If it's the 30-year-old trail that we talked about earlier, they don't need future care. Medicare doesn't have an interest. That's fine. Otherwise, we did an MSA. It's being professionally administered. It's being paid by annuity. Whatever it is, get all that in there. Spell it out. And then make sure to say something about Section 111. The carrier may have to report this, the ICD-10 codes, whatever it is, you can agree on what codes are being reported. You can get as specific or you can stay as vague as you want, but you want to make sure that they know if they're a Medicare beneficiary, something is going to be reported to Medicare. All right, we are going to round things out. We will be back with another Sanderson Firm webinar. I know how excited you all are. You don't have to wait until the very end of April like you had to wait this month. April 21st will be our next one. We will be talking about Medicare. What is COB? You're like, COB? What is that? Coordination of Benefits in Action. We will not be eating corn on the cob, but we will be talking about coordination of benefits in action, streamlining claims, and minimizing denials. If you get calls from Medicare beneficiaries saying my treatment is being denied because of my work comp claim, this is the webinar for you. Bridget and Kayla will be on this talking to you about what happens when you get that call, what to do, what Medicare guidance is out there for providers to stop them from behaving this way, and really why this happens and what you can do about it. So with that, I want to say thank you to Bridget for doing this with me. Thank you all for attending and for your great questions along the way. Bridget, anything you want to say to send us off?
Annie, we made it. Everybody, we made it through the trail. So thank you for joining us. High five, virtual high five, Annie.
There
Thanks,
you
everyone.
are. All right, we'll answer your questions if we didn't get to it via email. Thanks, everyone. Have a great rest of your day. Bye-bye.
Bye-bye.